Understanding Georgia labor laws is essential for both employers and employees to ensure fair treatment and legal compliance in the workplace. Georgia has its own set of labor regulations that sometimes differ from federal standards, creating a unique legal landscape that affects everything from wages to workplace safety. Georgia's minimum wage is set at $5.15 per hour, significantly lower than the federal minimum wage of $7.25. However, most Georgia employers must follow the federal rate if they engage in interstate commerce or have annual sales exceeding $40,000. Certain small businesses, domestic employers, and farm owners may be exempt from these requirements. When it comes to overtime, Georgia follows federal guidelines under the Fair Labor Standards Act. Non-exempt employees must receive 1.5 times their regular pay rate for hours worked beyond 40 in a workweek. Several categories of workers are exempt from overtime requirements, including executives, administrative employees, professionals, outside sales representatives, and certain computer professionals. Unlike many states, Georgia does not mandate meal periods or rest breaks for adult workers. If employers choose to provide short breaks under 20 minutes, these must be paid. Longer meal periods of 30 minutes or more can be unpaid if employees are completely relieved of their duties. While Georgia encourages employers to provide unpaid breaks for nursing mothers, there are no strict requirements beyond federal standards. Georgia does not require employers to offer paid vacation, sick leave, or holiday time. However, if an employer establishes such policies, they must adhere to them consistently. The state follows Federal Family and Medical Leave Act requirements for eligible employers with 50 or more employees, allowing up to 12 weeks of unpaid leave annually for qualifying conditions. For military service members, Georgia provides additional protections beyond federal law. Employees can take up to 6 months of leave every 4 years for military training or service schools, and must be reinstated upon return. Georgia also prohibits employers from penalizing employees who respond to jury duty summons and requires reasonable time off for voting. Georgia is an at-will employment state, meaning employers can terminate workers for any reason that doesn't violate anti-discrimination laws. When employment ends, employers must pay all earned wages by the next regular payday. No severance pay is required unless specified in an employment contract or company policy. Workplace safety in Georgia follows federal OSHA standards. The state has additional regulations regarding firearms in the workplace and smoking policies. Under Georgia's Smoke-Free Air Act, smoking is prohibited in most enclosed workplaces, though certain exemptions exist for specific businesses. Georgia employers must comply with federal anti-discrimination laws, prohibiting workplace discrimination based on race, color, religion, sex, national origin, age, disability, and genetic information. The state does not have its own comprehensive anti-discrimination statute, but does provide some protections against retaliation and wrongful termination. Non-compete agreements are enforceable in Georgia, but must be reasonable in scope, duration, and geographic area. Courts will evaluate these agreements based on whether they protect legitimate business interests without imposing undue hardship on former employees. Properly classifying workers as either employees or independent contractors is crucial. Misclassification can result in significant penalties and liability for unpaid taxes, benefits, and overtime. Georgia follows IRS guidelines that examine behavioral control, financial control, and the relationship between the parties to determine proper classification. For employers and employees alike, understanding Georgia labor laws is not just about legal compliance, but about creating fair, productive workplaces. While Georgia offers fewer state-specific protections than many other states, the combination of federal and state regulations provides a framework for employment relationships throughout the state.